We're back with part 2. And before we even move forward, let's pause for a second, because what we're looking at here isn't just another legal reply. It's the moment where everything that's been whispered, suspected, and quietly assumed finally shows up in black ink on white paper. The kind of moment that makes you imagine exactly how it felt to sign your name at the bottom of a document, knowing it could unravel an entire case. Last time, we stopped at the so-called contract, and before anyone tries to build arguments on top of it, we have to address the uncomfortable truth hiding underneath. There was never a real contract to begin with. That's not speculation, that's not spin, that's what the filings actually say. And seeing it stated plainly, bolded, printed, undeniable, hits very differently than just suspecting it all along. The claims being pushed rely on what are described as putative agreements. That word matters. Putative doesn't mean proven. It doesn't mean valid. It means alleged, treated as real until the law decides otherwise. In other words, these documents have been acted like contracts without ever being legally established as contracts. And now the court is being asked to decide whether they ever truly existed at all. There are two documents being leaned on. One is the Actor Loan-Out Agreement, often called an ALA. The other is the Contract Rider Agreement, or CRA. And here's where things begin to collapse. Neither one is enforceable. The Loan-Out Agreement was drafted with multiple prerequisites that had to happen before it could bind anyone. Those prerequisites never happened. No final version was agreed to. No execution took place. No signature sealed anything. Without those steps, there is nothing to enforce. The Rider Agreement fares even worse. It was never meant to stand on its own. It was designed to be folded into the Loan-Out Agreement as an amendment, but you can't amend a contract that never came into existence. That alone dooms it. On top of that, it lacked independent consideration, meaning there was no legal exchange that would make it binding on its own, even if someone wanted it to be. And even if, for the sake of argument, you pretended both agreements were valid, the claims would still fail. That's how deep the problem goes. Some of this language sounds deliberately dense, almost like legal noise meant to confuse, but once you strip it down, the logic is brutal and simple. Certain conditions were required before obligations could ever kick in. Those conditions never happened. When conditions fail, duties never begin. There are two types of these conditions. One type prevents a contract from even existing until something happens. The other allows a contract to exist but delays performance until a triggering event occurs. Here, execution, the act of signing, was the trigger. Without it, the other side's obligations stayed dormant, permanently. This isn't controversial law. Courts across jurisdictions have said it repeatedly. When parties clearly expect signatures to finalize an agreement, the absence of those signatures means there is no binding deal, no matter how much someone wishes otherwise. And this isn't just theory. The filings point to binding appellate decisions, higher courts that lower courts are required to follow, Supreme Court rulings, Circuit Court rulings, New York, California. The rule is consistent everywhere. No execution, no enforcement. That's why this argument is so devastating. Entire causes of action are built on the assumption that a contract existed. Take that away and the foundation disappears. But even assuming the contract magically sprang to life, there's another fatal issue, the notice and cure requirement. This provision required written notice of any alleged breach and a waiting period to allow the issue to be fixed before legal action could begin. That didn't happen, not even close. Instead of following the process laid out in the very agreement now being relied upon, the response was immediate escalation, regulatory complaints, media exposure, litigation, without waiting the required time or even properly notifying the correct party. That alone blocks enforcement. Courts have been clear on this too. When a contract contains a notice and cure clause, compliance isn't optional. And it's not the defendant's burden to raise it. It's the plaintiff's burden to show they followed it. That didn't happen here. And it gets worse. The letter that was sent didn't even reference the alleged breach or address the proper entity, yet claims were filed just days later, far short of the required window. That's not a technical slip. That's a direct violation of the terms being invoked. Then there's damages. Even if everything else survived, the damages wouldn't. You cannot recover twice for the same harm. Tort damages and contract damages cannot mirror each other. Courts don't allow double recovery, and here the claimed losses overlap completely. Worse still, the agreement itself limits recoverable damages. Speculative losses, future profits, indirect business opportunities, those are explicitly barred. And the call law cited actually confirms that future hypothetical earnings in volatile industries like film, fashion, or startups are too uncertain to be awarded. Hair brands that might have taken off, films that might have been made, deals that might have happened. Courts don't compensate for maybes. On defamation and false light, the situation is just as bleak. The claims rest entirely on statements made by attorneys during active litigation. Those statements are privileged. They are protected. That protection exists for a reason. Lawyers must be able to defend their clients without fear of being sued for doing their jobs. Defamation requires falsity and malice. Neither has been shown. Opinions are protected. Responses to public accusations are protected. And cherry-picking phrases while ignoring context doesn't change that. Even the argument that statements suggested dishonesty collapses under basic logic. A denial, by definition, asserts that an accusation is false. Calling that defamatory would silence every defense attorney overnight. Courts are careful about this because the stakes are enormous. Allowing claims like this would chill speech, chill advocacy, and undermine the adversarial system itself. The choice of law gymnastics don't help either. New York when it's convenient, California when it's not. Trying to resurrect doctrines one jurisdiction has consistently rejected by borrowing from another. Courts see through that. They always have. The conspiracy claims fail because conspiracy isn't a standalone claim under New York law. It lives and dies with the underlying torts. When those fail, conspiracy goes with them. And then there's the effort to rope in individuals without evidence. After all the noise, all the insinuation, nothing concrete was defended. No proof, no substantiation. When the moment came to put cards on the table, there were none left to play. This stage of litigation isn't theatrics. There's no dramatic reveal waiting in the wings. This is survival mode. If it isn't raised here, it doesn't exist. And that's why the silence matters. Because silence at this point doesn't mean strategy. It means absence. Speculative losses can't be recovered. Reputational harm must be personal and provable. Hypothetical futures don't qualify. When you strip everything away, the language, the emotion, the spectacle, you're left with something very simple. No contract, no execution, no notice, no damages, no defamation, no conspiracy. And that's why this filing lands the way it does. A clean dismantling, a methodical collapse, and a final grade delivered without hesitation. An F.
We're back. And this time, it isn't just another continuation. It's the moment where the entire story starts to crack open. Part 2 of the response has arrived, and before we go any further, there's something almost cinematic about this filing. The kind of document that makes you stop and imagine what it felt like to sign your name at the bottom of it, knowing it could quietly dismantle everything on the other side. Last time, we paused at the contract, or what was supposed to be a contract. And before anyone can honestly move forward, there are a few uncomfortable realities that have to be dragged into the light. Because the real shock isn't hidden in dramatic accusations, it's buried in the fine print, or more accurately, in what never existed at all. The bombshell doesn't come from new facts, it comes from confirmation. What many suspected all along is now spelled out plainly. There was no enforceable contract. Not problematic, not imperfect, none. And seeing that stated clearly, formally, in a legal filing, hits a lot harder than rumors ever could. The claims being pushed are built on what the document calls putative agreements. That single word changes everything. Putative doesn't mean real. It doesn't mean valid. It means assumed, treated as legitimate until a court decides otherwise. In other words, these agreements were acted like contracts without ever crossing the legal threshold required to make them contracts. Two documents are at the center of this.
One is the so-called actor loan-out agreement. The other is the contract writer agreement. And here's where the illusion collapses. Neither one can actually be enforced. The loan-out agreement was drafted with several conditions that had to be satisfied before it could bind anyone. Those conditions never happened. No finalized terms, no execution, no signature. Without those steps, there is nothing to enforce, no matter how much someone wants to pretend otherwise. The writer agreement is in even worse shape. It was never meant to stand alone. It was designed to be absorbed into the loan-out agreement as an amendment. But you can't amend a contract that never came into existence. Legally, it's like trying to renovate a house that was never built. And on top of that, it wasn't supported by any independent legal exchange that would give it force on its own. And here's the part that really stings. Even if you assume, purely for argument's sake, that both documents were valid, the claims would still fail, multiple times over. The language in the filing may sound dense at first, almost intentionally tangled, but once you translate it into plain English, the logic is ruthless. Certain events had to occur before obligations could ever begin. Those events didn't occur. When conditions fail, duties never activate. This isn't some obscure loophole. Courts have said this again and again. If parties clearly expect signatures to finalize an agreement, then the absence of those signatures means no binding deal exists. Period. That's why this filing lands so hard. Entire legal claims are built on the assumption that a contract existed. Remove that assumption, and the whole structure collapses under its own weight. And this is only the beginning. Now here's where the legal reality turns brutal, because this isn't about vibes or intentions anymore. It's about how contracts actually work when courts get involved. And this is the point where the entire argument starts slipping through the cracks. The filing goes back to something called conditions precedent, and this is not some technical footnote. This is the backbone of why everything falls apart. There are conditions that must happen before a contract even exists, and there are conditions that delay performance until a specific event occurs. In this case, execution, the act of signing, was the trigger. Without it, nothing starts. No duties, no obligations, no liability. This isn't a gray area. The motion states it clearly. The agreement was never executed, the final terms were never agreed upon, and the required inducement was never signed. Each of those was a prerequisite to triggering any responsibility on the production side. None were waived, none were ignored. They simply never happened. And that's devastating, because when a condition like that fails, the party whose obligations depend on it is legally excused from doing anything at all. You can't demand performance from someone when the event that activates their duties never occurred. Courts have ruled on this repeatedly. When parties expect written acceptance, and that acceptance never comes, no binding agreement is created. That's not opinion, that's settled law. New York says it, California says it, federal appellate courts say it, and lower courts are required to follow those rulings whether they like it or not. Which means this isn't a creative argument, it's a fatal one. And even if you pretend the agreement somehow survived that hurdle, the filing moves in for the next strike, notice and cure. This is where the irony becomes impossible to ignore. The same agreement now being relied upon included a requirement that any alleged breach had to be formally identified in writing, followed by a waiting period allowing the issue to be corrected before any lawsuit could be filed. That process wasn't optional, it was mandatory, and it wasn't followed. Instead of notice, there was escalation. Instead of a cure period, there was immediate litigation. Instead of giving the other side time to respond, complaints were filed within days. That alone blocks enforcement of the agreement, even if it were valid, which it wasn't. What makes this even worse is that the burden to show compliance didn't fall on the defendants, it fell on the plaintiff.
Courts applying California law have been crystal clear. Compliance with notice and cure provisions must be pleaded by the party bringing the claim. Failing to do so is fatal. The argument that the other side somehow waived this requirement by not raising it earlier doesn't work. The law doesn't support that. The obligation was hers, and it wasn't met. The timeline tells the whole story. Claims were filed barely days after a cease and desist letter, no 30-day window, no opportunity to correct anything, and the letter itself wasn't even directed to the proper party or tied to the alleged contractual breach. So even under the most generous interpretation, the terms of the agreement were violated by the very person now trying to enforce it. Then comes damages, and this is where the case really runs out of oxygen. You cannot recover twice for the same injury. Courts do not allow a plaintiff to dress the same harm up as both a contract claim and a tort claim and collect twice. Here, the alleged contract damages mirror the tort damages exactly. That alone defeats the contract claims. But it doesn't stop there. The agreement itself limits recoverable damages, speculative losses, indirect profits, hypothetical future opportunities, all excluded, which means the very contract being fought over would actually destroy most of the remedies being sought. And the court law cited to support the damages argument backfires completely. Courts have held that speculative future profits, especially in unpredictable industries like film, fashion, and startups, are too remote to recover. Movies that might have happened, brands that might have succeeded, deals that were never finalized. None of that qualifies. Even worse, several categories of claimed damages weren't defended at all in the opposition, and when arguments go unanswered, courts treat them as conceded. Silence at this stage doesn't mean strategy, it means surrender. And that's when the filing turns to defamation and false light, and dismantles those too. The claims are based entirely on statements made by attorneys during active litigation. Those statements are privileged, they're protected, and for good reason. Lawyers are required to defend their clients against public accusations. Defamation requires falsity and malice. Neither is shown. Opinions are protected. Context matters. Cherry-picking phrases doesn't change that. The suggestion that denying accusations is itself defamatory collapses under basic logic. A denial necessarily implies the accusation is false. That's the definition of a denial. If that were actionable, no defense attorney could ever speak. Courts are deeply cautious here because allowing claims like this would chill advocacy and undermine the justice system itself. That's not hypothetical. Judges have said it outright. And when it comes to timing, the problems multiply. New theories were raised too late. Claims not pleaded in the complaint cannot suddenly appear in opposition papers. That door is closed. Even attempts to stitch together statements into a new narrative fail. The words being attributed were never spoken as a single accusation, and courts don't allow creative reconstruction after the fact. The privilege protecting statements made in anticipation of litigation is broad, extremely broad, and it cuts both ways. Reporting on judicial proceedings is protected. Responding to public filings is protected. Anticipating litigation is enough. And when one jurisdiction protects these claims, trying to revive them by hopping to another jurisdiction doesn't work. New York has consistently rejected false light claims. Courts there do not allow them to be smuggled in through choice of law tricks, which brings us full circle to the contradiction at the heart of this case, rejecting an agreement when it's inconvenient, then clinging to it when it might help, choosing New York when it suits one argument, then California when another doctrine is needed. Courts see that for exactly what it is, and at this stage, there's no dramatic reveal coming later, no secret evidence waiting for trial. This is survival mode. Everything had to be played now. The fact that so many arguments weren't defended tells you everything you need to know, because when the stakes are this high, silence doesn't mean patience, it means there's nothing left.